Supreme Court of India Vaibhav versus the State of Maharashtra decided on June 4, 2025 0 NSC 800 facts of the case. Vaibhav and Mangesh, who were studying, they used to commute together on their two-wheelers. On the fateful day of September 16, 2010, both friends left the college together on the scooter belonging to Mangesh, had tea at the tea stall of prosecution witness 3 and arrived at Vaibhav's house in the afternoon. When Mangesh's father/prosecution witness 1 discovered late in the evening that his son had not reached home, he tried to find out and eventually lodged a missing report. The next day, on September 17, 2010, the dead body of Mangesh was found. Trial court found that the appellant had killed Mangesh and was found guilty for the commission of the offences under sections 302, 201 read with section 34 of IPC and section 5 read with 25, 1a, of Arms Act. His friend Vishal was also found guilty for the commission of the offence under section 201 read with section 34 of IPC. High Court upheld the conviction of the appellant and Vishal was acquitted for want of evidence. Findings of the court: in a case based on circumstantial evidence, answers to such questions are not found on the face of the record. Rather, the truth is found concealed in the layers of incriminating and exonerating facts, and the court is required to arrive at a judicial finding on the basis of the best possible inference which could be drawn from a comprehensive analysis of the chain of circumstances in a case. The version of the prosecution is simply that the appellant shot the deceased in the eye and there has been no effort to prove the directions of entry or exit or to explain the inward or outward journey of the bullet. The prosecution version remains acceptable only till the point of entry of the bullet through the eye, but it starts becoming cloudy when the upward trajectory of the bullet is analyzed. The probability of the version put across by the appellant is on the higher side as compared to the version put across by the prosecution, which simply does not give any explanation for the trajectory of the bullet. The inconclusive opinion of prosecution witness 9 regarding the death being homicidal or suicidal/accidental was also a relevant fact. In the present case, the version of the prosecution suffers from inherent inconsistencies and doubts, as discussed above, and in such a scenario, the inability of the appellant to explain certain circumstances could not be made the basis to relieve the prosecution from discharging its primary burden. Despite a specific defense taken by the appellant before both the courts, the court simply did not examine the same in the manner required by law. Thus, a complete absence of motive, although not conclusive, is a relevant factor which weighs in favor of the accused. No doubt, the final effect of such absence on the outcome of the case shall depend upon the quality and weight of surrounding evidence. In the present case, the testimonies of prosecution witnesses have invariably revealed that the appellant and the deceased were friends and there was no ill will between them. Even the father of the deceased has testified to that effect. Thus, a complete absence of motive, although not conclusive, is a relevant factor which weighs in favor of the accused. No doubt, the final effect of such absence on the outcome of the case shall depend upon the quality and weight of surrounding evidence. In the present case, the testimonies of prosecution witnesses have invariably revealed that the appellant and the deceased were friends and there was no ill will between them. As regards the subsequent conduct of the appellant, before parting, we may also note that the same was consistent with the theory of accidental death. That his act of removal of the dead body and concealment of articles was a result of fear of his father is quite natural. No doubt, the subsequent acts of cleaning up the crime scene and making false inquiries amount to disappearance of evidence and raise grave suspicion against the appellant. However, mere suspicion, no matter how grave, cannot take the place of proof in a criminal trial. In the present case, the theory put across by the appellant is fairly probable and is supported by medical evidence including the examination of the bullet injury and trajectory. Contrarily, the conclusion drawn by the courts below is not supported by medical evidence and is not consistent with the bullet injury and trajectory. As discussed above, in light of the foregoing discussion, we hereby conclude that the High Court has erred in arriving at the finding of guilt and in upholding the verdict of the trial court. Consequently, the appellant is acquitted for the offences under section 302 of IPC and section 5 read with 25, 1a, of Arms Act. His conviction under section 201 IPC is sustained and he is sentenced for the period already undergone by him, for reasons discussed above.